Well, greetings again. Today we're going to do lesson 20. And with this lesson we'll have completed 2/3 of the 30-lesson course here on constitutional law, designed to teach the housewife from Kuna, Idaho, how to go into the Supreme Court of the United States and argue a case and win and do it every time. Well, so far our record is intact. In fact, I just heard of a case from one of our students over in Gem County, Idaho. I want to open this lesson on an upbeat note and tell you what happened to a fellow who's won 9 cases in succession in the traffic court over there. And this last case, being no exception to this young fellow, he went before the judge and he'd already heard on the street that they wanted to dismiss the case. So he went over there with another fellow, and they sat down in the courtroom, and as the judge began the hearing to dismiss, the fellow rose up and he said, Your Honor, I have some Sit down, Mr. Jones. Okay. And he sat down, and pretty soon the judge came down with the final words, This case is dismissed. Objection, Your Honor. I object to the state dismissing this case. Why, I've spent a number of hours and a lot of money, and I have a case here, and I want it to go to the jury. And he told Jones to shut up. And he said, but I've spent a lot of money on this case, Your Honor, and I demand that the state then reimburse me for my out-of-pocket expenses. And the judge couldn't contain himself. And he said, now you know as well as I do, Mr. Jones, that there is no lawful money, and because there's no lawful money, the state cannot pay you. And that's where the case ended. So you see, after a year's time, we have a judge in the 3rd Judicial District of Idaho who knows and understands that there's no lawful money. All right? So, with a little upbeat story there's one thing I wanted to add to this lesson 19, which I guess you have just seen, which I just completed. And that was this thing of your defense and your defensive strategy. And I outlined 10 or 15 of those defensive strategies there for you in lesson 19, and a new one just came in. You know, there's no end to defenses. I don't know how many there are because I don't know the particular circumstances of your case, but a young fellow here who's a student has been arguing a tax case in front of the Idaho State Tax Commission. And they want him to file a tax return for 1980 and 81. And he put forth a pretty substantial argument, and he's been working on this case, I think, for about 4 or 5 months at least, maybe half a year, maybe a little longer. The other day it came to our attention that the statute that they're trying to enforce upon him to file a tax return was passed in 1982, but the taxes that they're trying to collect is 1980 and 81. Now what does that tell you? A young fellow came in with a brief the other day and he said, Mr. Gordon, would you take a look at this? And I opened it up. Well, how's it going? And I read the first 2 paragraphs in which he outlined the ex post facto law case, and I said, there's your winning argument. You just won that case. And the reason for that is that, see if I've got my book out here on legal quotations. Let me show you something. Here's a student. He's a graduate. He has some gray matter between his ears, and there's some knowledge in that gray matter. And listen to this. An income tax liability for any 1 year constitutes a single cause of action. That comes from Lewis versus Reynolds, 284 U.S. 281. This young fellow simply said, wait a minute. The tax year 1980 is a single cause of action. It's an income tax liability for any 1 year. And that constitutes a single cause of action. And the law that they're trying to enforce upon me was passed by the legislature in 1982. It's an ex post facto law, and I don't have to file. And that's the end of it. Now, as you know, that for every offense, there's a defense. As soon as somebody comes along and invents a club, somebody will come along and invent a spear. And as soon as somebody comes up with a spear, somebody will come up with a shield. And as soon as somebody comes up with a shield, somebody will come up with a bow and arrow. And then will come up armor. And then will come up gunpowder. And so on down the line. And the same thing is true when you're dealing in the courts. For every strategy that comes up like this ex post facto law, pretty soon those prosecutors will drop those older tax cases when that subject is brought up and then they'll come down on you in 82, 83, 84, and so on down the line. But those are different causes of action. So you're going to have to learn to come up with defenses for their offenses and offenses to overcome their defenses. That's what makes this whole game of law in the courtroom so much fun, because that courtroom was designed for you. It was designed by your founding fathers for you personally to get redress of grievance on a personal, individual basis. And that's where you get it. But instead of that, what we find is the citizen is running from his courtroom as fast as he can. The rabbit does not want to go into the briar patch. Now, I don't know why that is, but I guess we've been taught that rabbits don't belong in briar patches. Now, getting on to lesson 20 then, this is putting your case together. The case file folder, research the statutes, research the code, research the case law, how to use the library, planning your case and putting it together, and then having a final plan together. All right? Now, these last 10 or 11 lessons that we're going to get here are going to be designed now to get down to the nitty-gritty. As I've said in a couple of lessons before, by now you should be pretty knowledgeable in all things like counsel, juries, due process of law, motions, motion hearings. In other words, you should have some terms down now so that when I begin to use some words that are used commonly in the courtroom, they shouldn't baffle you. You shouldn't, at this point, I believe, become so unfamiliar to you that you're sitting there at motions, affidavits, briefs. What are those? So you're going to have to know what those are, because from now on we're going to have to talk in legal terms. So let's see whether or not your legal vocabulary is up to the task by this point in time. Let's pull out lesson 9 and let's keep that in front of us here while we go through this lesson 20. This isn't a file folder, and your case is not going to be put together in this form. It's going to be put together in this form. And by the time you get up here now to lesson 20, your file folder is going to be just about this thick. It should be about an inch thick, have 40, 50 motions. It should have all of your complaints and everything in this file folder that you're going to use when you go into the courtroom for that trial. Bearing in mind now that everything that you're going to appeal on rights issues. Now, rights issues, that's counsel, juries, right sua sponte, whatever it is that you've got in, is right here in this file folder, and you set it out prior to trial. And what you're saying, in effect, is, Judge, we can't go forward until you give me a grand jury, supplant this information with an indictment, get a prosecuting attorney, a public prosecutor instead of this prosecuting attorney. I'm going to make you dot every I and cross every T. And the purpose for that is that you're telling him then, we can't go to trial because you're not granting me all of my common law rights that I'm entitled to. And I'm that belligerent claimant in person who's claiming and demanding those rights. So that's the effect of this file folder. All right? Now, in order, if this were in a file folder like this, then you need to have a nomenclature. So I use these legal file folders, and right up in the very beginning of it, I have 3 pages. Number 1 through 27, number 28 through 45, number 46 through 58. Let me just show you here on this TV screen the way I've laid this out, so I don't lose and drop everything. Oops, that isn't going to work. Let me get a hold of this a little better. I want to give you an idea what this looks like. When you open the file folder up, you'll notice over here now I have a yellow page, and that yellow page has been taped in. And every time I put a piece of paper into this file folder, I write notice of hearing date and the date right here on this nomenclature. And I'm going to show you how important that is. When the prosecutor goes into the courtroom, he has a file folder like this, and these fellows trade off all the time. And right on the face of it over here, they put the disposition of the hearing and the position that they're in at that moment in time, so that anybody else can come pick up that file folder and everything is in there in order. It's in there in order of time sequence as to these motions having been filed with the clerk. All right, so on day one, the number one item you want in there will probably be the information or complaint. And number two, the tickets. And number three, the trial setting date. You need everything in absolute and perfect order. When you get into that courtroom, you want the prosecutor grasping and looking for numbers over here, remember? You and the judge have yours numbered in order. The prosecutor doesn't. But remember, he's not going to be tricked more than once. And once you've laid him away on that subject, he's going to get wise to that, and then he's going to put those in there, and he's going to have them numbered in his way so that when you bring up motion for right sua sponte, that he can go put his finger on it. So when by the time you get to trial, if you haven't won, if you haven't gotten a dismissal up to the trial day, then you can just about bet that that prosecutor is going to be right on top of this file folder because you've laid him away a couple of times. And now he's going to be angry with you. See, now he's out to get you. Boy, I'm going to lay you away. I've had it with you, Gordon. I'm going to do something bad, wicked, terrible, and awful to you. All right? So now we know that we have gotten the rattlesnake stirred up. And he'll bite us if he gets an opportunity. This file folder should, by now, have all of your winning arguments in it. Okay, so now we're getting up here to where we want to put this case together. When we walk into that courtroom, we want to be totally prepared. So you take a yellow pad, and you run down a checklist here by the time you get to lesson 20. And in this checklist, you want to make sure that this file folder is right up to date, because if you're like I am, you'll have a lot of the paper that'll be out of sequence. You'll have them numbered and they'll be out of sequence, and then you haven't reviewed this file folder. And the very first thing you're going to do at trial is to move for reconsideration in administrative and procedural matters. Move for reconsideration of all of your motions. And if the judge is typical, he'll deny all of your motions. But you're doing that to set the record, because there's two records now in the trial procedure, or in the entire case procedure. One is the transcript of the trial itself, and the other is the transcripts of all of the hearings that have gone up to that trial. Everything you're doing is designed to take you to Washington, but it comes in two forms, or two separate, or two, let's see how we're going to word this. There's two portions or two parts to the case. One is all of the case, all of the arguments of the case that you've argued up to the moment of trial. Right at that trial day, when you walk in, the judge is going to ask you, are you ready to move forward, Mr. Gordon? No, Your Honor, I'm not ready to move forward at this time. I have some administrative and procedural matters to bring up at this time, Your Honor. And I'd like to bring to the court's attention the motions that have been brought in pretrial argument, and I would like to bring each and every one of these motions to the court's attention and move for dismissal based upon my motions. That's denied, Mr. Gordon. Next. The reason for doing that now is this. If the judge or the prosecutor want to let you off the hook, they'll have already planned this behind closed doors, and that'll be their opportunity to dismiss on your motion for one of these particular motions that you've put in. They may not want this issue of the grand jury or information or prosecutor going up to the state Supreme Court, and by now they're well aware that your only purpose is to argue this case to the Supreme Court of the United States, is to move this case up the judicial ladder. Now prosecutors, and this is important for you to remember, prosecutors in these misdemeanor cases are only prepared to take these cases to the jury level. And the public defender is only prepared to go to the jury level. That's why I always ask a public defender, that's if you, in the early days when they were enforcing these on us, what you do is you go to the public defender and you say, well, now, are you competent to write the motion so that we can carry this to the Supreme Court? We've got some major federal questions that need to be asked here. Are you prepared to put a file together so that we can carry this issue to Washington? And he'll just kind of look at you like, hey, man, I got a busy schedule and I don't have time for this. You've been charged here with drunk driving, and I'm willing to help you to do that. But, this appeal thing, and they'll just kind of stutter and stammer around and wonder. That's why I always say, well, it's obvious then that you're not prepared to prosecute this case and to defend it to the Supreme Court, then it's obvious that you're too busy to handle this case. And I think you should voluntarily dismiss yourself. Will you tell the judge that? Because you have a right to be defended to the Supreme Court of the United States. And so when you know that your adversary is only prepared to go 2 rounds and you're psyched up and ready to go for 10, you know that he's probably going to beat you up in the first 2 rounds, but he's not coming out for the bell on the 3rd round. So if you can stay in there for 2 rounds, you'll probably win on the 3rd, or at least you'll force him out for the 3rd and the 4th and the 5th rounds. And remember, you're prepared to go clear to the 10th round. And all you need is for him to miss the bell for 1 round. All right. So let's check out the file folder. Now, if you'll notice in this one, I think this one's put together pretty completely. Your nomenclature is on your opening page. This is lesson 9, and I'm just going to kind of run through here for you. Now, you're not going to have it in this form. It's not bad if you have it in this form. That's this plastic binding at the top. You could do that, I guess. I never have. How you put your case together physically isn't all that important, but let me tell you, when you get into that courtroom drama now and you need to refer to your paperwork, when you have to have this information in front of you, you've got to be able to come up with it just like that. And you can't sit around stuttering and stammering and and I'll tell you, boy, I've seen people go in the courtroom and, well, let's see, I think I left that at home, and, well, let's see now, this is, I think that's in the back seat of my car. No, that's in the glove compartment. And I think I've got one of those. I think he gave me, well, let's see, that's probably in the trunk. Martha, I mean, that kind of baloney, is kid stuff. And if you're going to handle it like that, boy, you're so far out to lunch that you're not going anywhere. Every piece of paper that's in here is a winning argument of and by itself. It could be the winning argument. And remember, based upon Lesson 13, those 7 rules that the Supreme Court is going to judge this case by, they're only going to dismiss on one issue, and one issue only. And you want those issues logically and coherently put together in order so that when that judge starts going through your file folder, this is about the amount of time that he's going to spend on your case. I'm going to skip over that. Well, now, they're going to spend maybe 3 or 4 minutes looking at your case. Now, I'll tell you just how important that is. You ever notice that in a newspaper, they'll put a headline on there that catches your attention? North Koreans attack South. They don't sit there and tell you the last paragraph or the last sentence or the last 3 words of the article. They tell you the eye-grabbing eye-catcher, don't they? And that's the way your case needs to be laid out, because judges run through dozens of cases and lots of paper. And if you think that that judge or anybody is going to pick up a folder or a file, a case this thick on appeal, and sit down and miss Boss Hogg or some other nifty TV show to read every paper and every page, and then, oh, wait a minute, there's one out of order here. I'll go through and I'll sort through this case and I'll get these in order and then I'll read them. You can forget that. And a lot of cases, I suspect, are thrown out simply because they're not legible, they're not coherent, they're not in order. There's no way that the judge is going to sit there and spend hours of time putting your case together for you. Now, this sample criminal case for use with videotape lesson 9 is in order, or at least it's in pretty significant order if it's not 100%. There was one thing I noticed here that was a little out of order, and that was the dismissal. The motion in order for dismissal should be the last page in the case, and I noticed for some reason it's up here in the beginning with the rest of the prosecutor's paperwork. But nevertheless, basically it's pretty much in order. And I can look at the nomenclature in the front, and I can turn to any single case in here, any motion, any argument, because you never know during that trial when you'll want to bring up an issue, and you want to be able to turn to it just like that. All right, enough said about that file folder. But I can't emphasize now how important that is, because I've seen so many people go into the courtroom and they don't know whether their rear ends are border punched. And if that's offensive to you, then let's get real offensive here so that when you get in that courtroom, you don't forget that term. and that every document and every piece of paper in here you know, and you know exactly where to find it. All right, now when you're talking about researching the statute now, when you walk into that courtroom, when the prima facie case break comes, you want to have that statute right in front of you so that you can attack the prima facie case. Now remember, the prima facie case here is as soon as that prosecutor sits down and says, "The state rests, Your Honor," and as he's sitting down, "Motion time, Your Honor," and that's the first thing you want to do. Right now, right off the top of your head, boy, motion time. I'm challenging the state's prima facie case, Your Honor. Would you dismiss the jury? And it usually, in a misdemeanor case, occurs at about 10 minutes to 12 or 5 minutes to 12, because the prosecutor will gauge his case right up to lunchtime so that he doesn't offend the judge. And so here you come 5 minutes to lunch, and you're going to bring about a 30 or 45-minute oral argument into the case. If you don't think that wins friends and influences people, let me tell you. So I'm going to pull out the motor vehicle case here. Let's see, this was 49-115. Here's 49-319. Let's start right there for a prima facie case argument. Let me show you what I've done here in the past on this one. First of all, at 49-319, license to be carried and exhibited on demand. Every licensee shall have his operator's or chauffeur's license in his immediate possession at all times when operating a motor vehicle, and shall display the same upon demand of a justice of the peace, peace officer, a field deputy, or inspector of the department. However, no person charged with violating this section shall be convicted if he produces in court an operator's or chauffeur's license theretofore issued to him and valid at the time of his arrest. Now, Your Honor, I'd like to point out for the consideration of the court that the state has failed to prove that I'm a person who's required to have a driver's license. Let's take a look at the wording of this statute, because the wording is extremely important. Every licensee shall have his operator's or chauffeur's license in his immediate possession. The state has failed totally to prove that I am a licensee. As a matter of fact, Your Honor, a person who is not a licensee is not a person under this statute who could be compelled by the wording of the statute to produce an operator's license. Therefore, I move for dismissal, Your Honor, for failure of the state's prima facie case in Ride Code 49-319. If the state wants to bring the charges for failure to purchase a driver's license or failure to carry a driver's license, that's another issue. But license to be carried and exhibited on demand, Your Honor, is, first of all, an absolute requisite that I would have a driver's license that I could produce, remembering that the law does not require of a citizen to do that which is impossible. I've won on that very argument right there. Sometimes the police, and you want to remember this, this is extremely important because you're going to win a number of cases by simply being observant and on the ball, as they say. You know, policemen write these tickets, day in and day out, and they write a lot of them. Nobody ever challenges these things. And the policeman's standing there by your window, and he says, see now, what code is that? That's 49-319. Yeah, I think that's what it is. And he'll write down 49-319 when in reality, what he really wants is 49-320 or 49-321 or 322 or something else. And I'd say about 20% of the time you're going to see that occur. And when it occurs, that's your winning argument. But never bring it up until the day of trial, because you see, if you bring it up in a motion and you move for dismissal before the trial date, he can amend the complaint anytime up to putting that, I think it's any time in the state of Idaho up to the time the state rests its case. Now, I've had this happen a number of times, and here, let's just follow this through now and show you what happens. The state gets in there and they bring their witnesses in, and was this man driving an automobile? Yes, he was. And is this man the defendant, the man that you gave the ticket to? And oh yes, he's the party right there. It's the defendant, Mr. Gordon. And did this occur in Ada County? Yes, it did. And did this occur in Boise City? Yes, it was in Boise City on Orchard Street. And what kind of a car was that, officer? And well, it was a 1972 Pontiac, and it was a green one. And then what happened? Well, I walked up and I asked Mr. Gordon for his driver's license, registration, and proof of insurance. And then what happened? Well, he failed he failed to purchase a driver's license, and that's why I charged him with failure to purchase a driver's license. And they'll go through and they will prove that you failed to purchase a driver's license, you see, but they've charged you with 49-319. And 49-319 is not failure to purchase a driver's license, it's failure to display or to produce. Now remember this. Your common sense says, well, what difference does it make? You don't have a driver's license. If you don't have a driver's license, failure to purchase, failure to produce, failure to carry. I mean, what difference does it make? That's street vernacular. When you're talking about law, the law is, what does it say there and what do those words mean? Because if they're in there proving 49-320 and they've charged me with violation of 49-319, they've lost their case. Because the moment I challenge that prima facie case, I've had judges in both directions. Sometimes the judge will, well, I'm not going to dismiss. I'm going to allow the state to amend the complaint, which is a violation of the rules, which is winnable on appeal. Or they'll dismiss. And if the judge dismisses, then you've won that issue. Now, if you've been charged with you've got 6 tickets, and this is one of the 6, now you've only got 5 left. You've won 1, and you've got 5 left to win. And so you've knocked off 1. There's a victory. Now, when that prima facie case issue comes up, and I'm going to send this to you. Let's make sure we get this written down. This is Idaho Code Motor Vehicles 49-320. Just take a look at this. I'm going to refer to this again as I go through this lesson, but keep in mind that whether it's driver's license, registration, proof of insurance, OSHA, EPA, I don't care what the charge is or what the issue is about. You always go get the statute and make sure they've charged you with the right statute. Let me give you another illustration of a case that we won here in Idaho because there was no such law. I was actually charged with breaking a law that never existed in this state. And my partner pled guilty to breaking the law that never existed in this state and paid the penalty to it. And I won the case, and he has no appeal because he pled guilty. Here's essentially what happened. The EPA came over, and they gave us a ticket, and they charged us with polluting the air. Okay, that's fine. There's probably some statutes that would cover polluting the air, but they went and they pulled a California regulation out of the EPA rules in California, and when they wrote up the complaint, it was a complaint just like this one. It said a complaint criminal, State of Idaho versus George Gordon and Atlantis Manufacturing Company and so on, I think it said, and went on down here, did willfully and maliciously, and all of which is contrary to the form, force, and effect of the statute in such case. And the first thing that we did, we went to the law library and said, let's find this statute. And it wasn't there. Now, the EPA inspector, not being a lawyer, you see, he didn't know and understand that the laws of California don't apply in Idaho. He thought that EPA rules that he was getting out of books, probably, he had a lot of books on his table just like I do, on his desk. And so he just wrote that up. And the prosecutor, who's been to law school and should have caught that, if he'd have read the complaint, he'd have seen that the numbers that were used in the statute did, in fact, violate Idaho Code 187001, or whatever the number was. See, in Idaho, all misdemeanors and criminal actions are designated by these numbers IC 18-7001. All right? And that's the code number. It's just like a Social Security number. And every state has a little different system. Or nearly every state does. I notice that when I look at Rhode Island, if you got a statute in Rhode Island or New York, they have a different set of numbers, a different type or methodology of putting numbers and letters together. It's a different code, right? Just like license plates. And that prosecutor should have caught that and amended the complaint, but instead of doing that, the state went through and presented their entire case, to which we stood up and said, there is no such law in the state of Idaho, and we moved for dismissal for failure of the state to prove a prima facie case. That's probably against the law in California, but we're not in California. That's probably against the law up in British Columbia or out in Quebec or over in Germany, but we're not there. We're in Idaho, and Idaho doesn't have any such law. It's not against the law to breathe in Idaho. It may be against the law to breathe up in British Columbia, but not here. And so the judge just looked at that, dismissed. Now, you know the judge had seen this very same file folder for some 3 months before we went to trial, and that judge may have picked that out. Remember I told you that there was a judge down in Gooding County that put his arm around my neck one time, or around my shoulder, and he said, "Boy, I wish I had this case. I'd win it in 5 minutes." And he went right on up there and sat down on that bench and presided over the jury's verdict of guilty. And then looked at me with a grin on his face and said, "Now, Mr. Gordon, would you like to waive the time for sentencing, and shall I sentence you today?" Okay. So judges and prosecutors and lawyers and people may be able to pick out the winning argument, but that judge is supposed to keep his mouth shut. He's not supposed to tell that prosecutor, "Hey, you need to amend this." He can't come to you, the defendant, and say, "Hey, I'll show you how to win this case in 5 minutes. The prosecution over here is out to lunch." That judge has got to have his neutral hat on. This is an adversary proceeding. Always remember that. Remember Miranda versus Arizona. Adversary proceeding. So the judge sits there and watches the ball and calls the fouls and calls the net balls, and nothing more and nothing less. He's the referee. It's up to you to bat the ball back and forth across the net. And it's up to your opponent to bat the ball. And when he doesn't, you nail him right to the wall. And there's your victory. Now, one time I had a fellow tell me, "Well, you didn't win in front of the jury. Well, you won on a technical issue or a technical motion." What difference does it make whether you win a TKO, the guy fails to answer the bell, or you knock him out? If you win, you win. If you lose, you lose. And in this game, there's only winners and losers. And there's no consolation prizes. You're either going to win or you're going to lose. And I'm a poor loser. So you better get into that game and play to win. And if you can win on the statute, then you win on the statute. And that's called attacking the statute. That's the word that we use on it. Or analyzing the statute. Whatever term you want to use. You look at the words. I'm charged with a case now of obstructing and delaying. Let me just lay this one on you and show you. This will give you a third example here. When you look up the words obstructing and delaying an officer in the course of his duty, what this arose, the way this arose, I'll give you a little background here, was this. I'm in the county jail. Somebody put me in jail because they said I didn't have a driver's license. And they wanted to take my fingerprints and my mugshot and I don't know what else. It's called booking. And I said, no. Don't forget Davis versus Mississippi. And I want you to remember, fellas, that you have to obey the law. Get a court order, and then you can book me in. There won't be any problem. And so they charged me with obstructing and delaying. So all I did was go to the law dictionary. And I went and looked up the word obstruct and delay. Now, if you're the person who's being arrested, and the policeman comes up and he grabs you by the shoulder and says, "You're under arrest," and you jerk away and you run away, that's not obstructing and delaying, that's resisting arrest. To obstruct and delay, the policeman comes up, puts his hand on my shoulder and says, "You're under arrest, Gordon." Some third party comes up and trips the policeman and knocks him down, and I run away. He's guilty of obstructing and delaying. The subject can never obstruct and delay. It's not possible because he's the subject. The subject can resist, but he can't obstruct and delay. Now they're going to try me on that. See? Watch what happens at the prima facie break. I sit here quietly, see? I'm not going to say a word. When we get to the prima facie break, I'm going to jump up. "Motion time, Your Honor." And I'm going to bring out the law dictionary, and I'm going to explain the words and the definitions. See, they should charge me with something else. Now, I don't know what they can charge me with because, remember, pursuant to, I think it's the Simmons case, we find it intolerable that one constitutional right should have to be waived to assert another. And there's a number of Supreme Court cases along that line. So I've got the case won already. I'm not concerned about that. But now, can I win it at the trial level? All right, now there's another thing that you want to remember when you're going into trial, and that is you always want to go to trial. When you're new and you're just getting started, you'll take every win you can get whenever you can get it. But after you've done 5 or 6 of these, you want to make them pay. I don't want to win at the motion hearings. What I want to do is I want to learn, or not learn, but I want to put up all of my constitutional issues and arguments, and I want to get it to a position where I know I'm going to win, and then I want to carry this thing to trial. Whether I win or lose at the trial is not important, because I know I'll always win on appeal, won't I? So if I can win on appeal, and I can force them into the trial and make them spend $1,000 or $1,500 on the trial itself while they're trying to collect a penalty of $200 or $300, I've deprived them of the profit that they're looking for. And that's what everybody needs to do. You get into that courtroom after your first 3 or 4 cases. Now, I'm not suggesting that you drag this on, if you're a novice. But when you've done 3 or 4 of these cases, it becomes more and more important for you then, if they keep after you, make them pay. And the more expensive it gets for them, the less attractive you're going to be in that courtroom. Until pretty soon they don't even want to have you in the courtroom. This case that I've got right here, that I brought out a little earlier, in a traffic case, occurred in April of 1982, and it's going to trial in September of 1983. That's about a year and a half. And it happens that we waived time on it for a strategic move. So they've been mulling it over for a year and a half. I'm going to go to trial. I'm going to be found guilty, and I'm going to appeal it, and I'm going to win. And I'm going to make them spend at least $1,000 to $1,500 on it. I would say that probably like this other fellow that I told you about right at the very beginning, this was his 9th win. He went there to have a jury trial. He wanted them to spend $1,000 or $1,500. I object, Your Honor. I don't want this case dismissed. Sit down, Jones. Dismissed. Why? Because they don't want to spend $1,000 on this guy. They know that they can't beat him. And so for that reason, they don't want him in the courtroom. And when you get to that point, and when you've got other people in your county at that point, you're going to begin to exercise rights and freedoms that you didn't even know existed. Pretty soon you can walk down the street, and I'm not suggesting that you should do this in a contemptuous manner, but in Pocatello they've got some fellows down there that they will not arrest for any cause or reason less than a felony. Now that's the word I've heard on the street up here. I don't know who those guys are down there, but I would say that that's probably pretty accurate. I know over in Jim County, this particular fella, they won't bother him at all. All right, let's take up the next issue here then, is researching case law. Now, the case law itself can be the winning argument. Now, I've just completed, let me just tell you where we're at. I have just completed the driver's license issue. It's a treatise about 50 or 60 pages long, and it's about 15 or 20 key driver's license cases. I can show and prove that driving is a right, and driving is a right based upon the Supreme Court and numerous state Supreme Courts that date back to 1876. In fact, Blackstone and Cooley tell us that driving or using the public roads is in fact a right. It is not a privilege. So when you go to court, there's an opportunity to win your case either prior to trial, at the trial, or after the trial on appeal based upon case law. So when you get a charge, I don't care what the charge is, but let's just say, for instance, as an example, it's the driver's license. You first of all, go copy the statute, remember? So you got your statute, and you're looking in here, and this is your code, and you're going to attack the statutes and the code. You're going to look for keywords and phrases. Obstruct, delay, resist arrest, and you're going to get the definition down and find out. Now, a lot of times, and I got a report back from Washington on a statute up there, boy, did they write that statute tight. I couldn't find a single thing in that statute that I could attack, any definitions or words or loopholes that they might have in that statute. They just weren't there. Okay, so there's no loopholes in the statute. So Okay, we're not going to win on that. What's the next line of defense? What do we do next? Okay, now it's the case law. So the case law then comes up under words and phrases or corpus juris secundum. So you go to the law library and you pull out, say, corpus juris secundum on, I think it was travel, driver's license, licensing, and you start reading cases along that line. It's also called shepherdizing when you're trying to find a group of cases in a row, you know, that show your position. Now, you're going to be right or you're going to be wrong, one or the other. And I don't care what the issue is. It can be fingerprints, it can be search warrants, it can be traffic, and I don't care what the issue is, but there is case law on it. Now, an interesting thing I saw not long ago was on our Second Amendment, pursuant to this thing of your right to keep and bear arms, the Supreme Court evidently has only ruled on that issue 3 times in our entire history. Evidently, it's so axiomatic that we have the right to keep and bear arms that the court hasn't been put upon but 3 times to make rulings on it. But you're going to find that under the Fourth Amendment, remember from Supreme Court, what is that now? Search and Seizure Law Report, of which by now you've read about 100 cases out of Search and Seizure Law Report. All right? That Fourth Amendment has been ruled upon and is ruled upon more often than any other section of the Constitution. But whether it's driver's licenses, and this thing of driver's licenses and rights comes under the 14th and the 5th Amendments. And it's been ruled that way. And that's the way you'll get dozens of cases. And this corpus juris secundum is the place you want to go, because all of the state Supreme Courts will be in there, and I mean literally there will be hundreds of state Supreme Court cases and lower court cases that talk about licenses and registration, where it came from. That's, after all, that's the way I researched that. And as I researched it and I put the cases together, here's a case and there's a case, there's 2, 3, 4, 5, 6, pretty soon you've got 10 or 15 cases. And when you take those 10 or 15 cases and start underlining, you know, the meanings and the facts, what have the courts said pursuant to facts and pursuant to law? And the courts will go back to Cooley and Blackstone, and they'll say that using the roads is a right. So the principle then is this. Whenever you're doing case law research, the case law research then is to find out what the courts have said. And if the courts say you're wrong, well, then you'll know it before you ever go to trial, won't you? There's an old proverb that comes up. Does a king go out with 10,000 to meet 20,000, but that he doesn't sue for peace? I mean, if you can see that you're wrong, well, then you might as well figure, I guess I might as well back up and sit down and shut up. It's when you're right that you want to charge forward. And in order for you to determine whether or not you're right, you have to research the case law on the subject matter that you're talking about. It's absolutely imperative. Now, let me throw out a real wild statement to you. I know most people are against dope, and most of the cases that are coming down in recent years are on drug cases, because in the 20s it was the Volstead Act and illegal hooch. Those were the key cases, like the Carroll case came down. But the court is constantly ruling on this thing of drugs. We've come to the conclusion here at the school that you can grow marijuana in your backyard and do so lawfully and legally under the police powers that have been set down by the Supreme Court of the United States since 1880. There's a couple of hitches. Let me explain this. Once the state of Idaho, as an example, passes a statute and says that marijuana is a controlled substance and you can't buy, sell, and trade it, etc., that's the law of Idaho. Now, over in California, they've got a lot less restrictive laws on marijuana. I believe that, in 5 or 10 years, you're going to find that marijuana will be a taxed and regulated commodity in the same way that Jack Daniel's whiskey is a regulated commodity. Remember, in 1925, a bottle of Jack Daniel's could put you in the penitentiary. But in 1935, a bottle of Jack Daniel's was just an article of commerce. Today, marijuana will put you in the penitentiary. Mark my words, 1990 comes along and it's just an article of commerce. It's the way law is. It's the old Roman commercial law, nothing more or less. But the point to keep in mind now when you're going into that courtroom, from this point on now in these next 10 lessons, is that now we need to win. So as a controversial argument, I could go into the courtroom and say, but I have a right to this marijuana. That marijuana is property, and property is one of the three basic inalienable rights. I have a right to life, to liberty, and property. And my government can't tell me whether or not I can have corn or wheat, or marijuana or heroin, or Jack Daniel's whiskey, or anything else. Because if it's property, I've got a right to it. But if it's contraband, it's illegal and unlawful. So you need to understand then the difference between contraband and property, because if it's contraband, mister, you've got a problem. If it's property, you don't have a problem. You know, I don't want anybody to misunderstand. I'm not advocating that you go out and grow marijuana in your backyard. I don't know if it's good or bad or right or wrong, and I don't take a position. Remember, I'm not a politician. I'm not here to say that you should or shouldn't do it. I'm here to say that if you determine for yourself that you want to do it, that's freedom of choice. And the difference between freedom and slavery is, did you make the choice, or did the government make the choice for you? A free man makes his choices for himself. Well, the police powers are lawful powers of the state to protect the life, liberty, and property of people. And there's no problem with that. But in the protecting of life, liberty, and property, the police powers cannot, absolutely are forbidden to trespass upon rights. But that doesn't mean that rights cannot be regulated under the police powers. And in this new book that we're putting out on the driver's license issue, which we should have ready, well, I'd say in another 30 days, I think it's at the printers right now, we'll show you absolutely, incontrovertibly, that driving is a right, but it's a right that can be regulated under the police powers. Now watch how this comes down so that you don't get trapped into trying to defend the left side of the issue when you're wrong. I would never suggest that the state of Idaho cannot pass a law that says all of us have to drive on the right-hand side of the road. And I would never say that the state of Idaho cannot pass a law that puts a sign up at an intersection and says stop. Because that's absolutely a proper regulation of a right. You have a right to drive on the road, but you don't have a right to drive on the left side of the road and force everybody else off in the ditch, or to force them to drive on the other side. So the rules of the road are the law. And the law, remember, is reason, logic, and common sense. So the state passes the law, doesn't it, then, to protect all of us on the road. So all of us drive on the right side, and none of us have head-on crashes, do it. And all of us always stop at the stop sign, and when we stop at the stop sign, and let the other guy go first, and then we go secondly, it prevents accidents, right? And we understand that. But what happens if you drive on the left-hand side of the road? Let's suppose that there's nobody else on the whole road over there, but there's a policeman hiding behind a fence, and you reach over here and you push the cigarette lighter in and you wander over the line and you come back like this and the policeman stops you. I'll give you a ticket for going over the center line. Wait a minute, officer. I think you've made an error here. There's no corpus delicti. You see, there's no loss. Now, the thing that puts you on the right side of the issue is that you don't have a driver's license wherein you agreed to be regulated by that policeman. It's only when you run into that guy on the other side or cause a damage that you've caused a loss. And don't be afraid to argue that in the courts, because that's common law doctrine. But if you've got a driver's license in your pocket, you have volunteered to be regulated. And if you have volunteered to be regulated, friend, then as a matter of law, I would like to encourage you not to go into the courtroom and start arguing superfluously these rights issues when you're obviously on the left side of the issue. And I don't want you out here robbing Circle K stores either, because robbery is a common law crime. What we're trying to do is to teach citizens how to claim their rights and how to stop being ripped off by the police powers being used by your state to collect taxes. That's absolutely forbidden by our Constitution. They can't use the police powers to collect taxes, and that's all that traffic code is. They've conned you into volunteering into that regulated enterprise, and then they fine you regularly. What do you think a corporation with OSHA inspectors coming in regularly is? It's using the police powers to tax. And let me tell you, when you're in a regulated enterprise, they can use those police powers to tax.